The right to sublease or assign is often not given much attention during a negotiation. However, they can have a dramatic impact on your situation later in the lease. These issues normally come up when your company is experiencing significant change, either growth or contraction, and therefore needs to make changes in the real estate strategy. They might not feel important when you're negotiating your lease, but they have the potential to become extremely important at a later date, so it's important to give them their due attention. Having these rights will increase flexibility and reduce risk, but there are a few things to watch out for. Let's start by understanding the difference between a sublease and an assignment. In a sublease, you, the tenant, retain primary liability for the lease payments. You are the sublessor and you bear direct responsibility for any default by the sublessee. You collect rent from the sublessee while you continue paying your rent to the landlord. And you must continue paying the landlord regardless of what payments you do or don't receive from your sublessee. You will often have to make sure the space is in functional condition for your sublessee, so in a way you become the de facto landlord. In an assignment, you are simply a guarantor of the lease, while the new tenant has primary responsibility. So the new tenant is dealing directly with the landlord, and you've been effectively removed from the process. But keep in mind, if the new tenant defaults on the lease terms, then you will have to step in and make the landlord whole because you are a guarantor of the lease. There is something called a novation, in which you would be absolved of all liability, meaning that you would assign your lease to the new tenant and have no liability of any kind going forward. Novations are extremely rare, and very few landlords will agree to giving one. There are a few questions that I often get when discussing subleases and assignments. First off, who gets the profit if the sublease rent is higher than the rent you're currently paying? The answer is that it depends on what's negotiated, but it's common to split the profits with the landlord 50-50, net of any leasing costs. Let's say, for example, you sign a 5-year lease on an office space, and then 2 years into the lease, you decide that you need to sublease it. In that case, your main cost would be the leasing commissions, any build-out you do for the new tenant, and the legal fees. Now let's say you're lucky enough to sublease your space at a higher rent than you're currently paying the landlord, which means you've got some profit. You would first deduct the costs I just described from the profit and then split the remaining amount with the landlord. In some cases, the landlord will insist on retaining 100% of the profit, and in some cases, you can retain 100% of the profit. It depends on what is customary in that particular market and how hard you want to push on that deal point. But 50-50 is a common solution. Most tenants are comfortable with it, most landlords are comfortable with it. Another question is, who takes the loss if the sublease rent is lower than what you're paying? The answer is simple. You do. You are the primary tenant, and therefore, regardless of any subleasing you do, you are responsible for paying the rent that is stated in your lease, which is usually referred to as the master lease. Another question. Can the landlord stop you from doing a sublease or assignment? Simple answer, yes, they can stop you. However, most leases will require that the landlord have substantive reasons for doing so. The way it's usually phrased in a lease is that the landlord must approve any sublease or assignment, but such approval cannot be unreasonably withheld. You can ask your attorney how unreasonable is defined. And I would point out this issue is a good example of why it's important to have an attorney who not only specializes in office leasing, but is also familiar with the local market. In that case, he or she can give you a better explanation of what is typically considered reasonable or unreasonable. This can be particularly important if you think your company might be sold. The reason is that when you sell a company, you typically assign the lease to the buyer. And if the assignment is denied by the landlord, then it could impede the sale of your company. The way to avoid this problem is to make sure that your attorney has inserted the proper language into the lease that will prevent the landlord from blocking the sale of your company by denying an assignment.